Hello, everyone. This is Stephen Richardson, and today we're going to be talking about question number two, which is a constitutional law question from the February 2012 California bar examination. The following information discussed should not be construed as legal advice. This is just an outline. I honestly, I wish I had this 15 years ago when I was going through law school. It would have helped so much in class and for the exam. Okay, so this is the information that you will see at the bar exam. I snipped it right from the exam. Uh, Press pause and read this. It's good information to know what exactly they want. So now we're going to break down this question into an online format using mnemonic memory guides and checklists from my website, lawschool-essentials.com. You can buy these very cheap and they'll help you out. Okay, first of all, you read the call of the question first, always. Does the city's refusal to allow AAO to use the bulletin board violate the rights of AAO's members under the First Amendment to the U.S. Constitution? Discuss. Immediately, you should be focusing on that First Amendment. Now you read the fact pattern. City recently opened a new central bus station. Within the central bus station, city was provided a large bulletin board that is available for free posting of documents. City requires that all free posted documents be in both English and Spanish because city's population is about equally divided between English and Spanish speaking people. City refused to allow the America for Americans organization, AAO, to use the bulletin board because AAO sought to post a flyer describing itself in English only. The flyer stated that AAO's primary goal is the restriction of immigration. The flyer also advised of the time and place of meetings and solicited memberships at $10 each. So, what you should be thinking now, you have 5 minutes to read this. It's a public defendant, right? So, it's a constitutional law. The time, manner, and place, substantial government interest. You've got a private organization, the AAO. So, 14th Amendment should be coming up, the Equal Protection Due Process Clause. The First Amendment, free speech, should be popping into your mind too. And the organization's purpose is the restriction of immigration. And then, if you have time, you should be thinking about a remedy, which would be injunction. The remedy would be if you have time. That might be some bonus points for you on the exam. So you had 5 minutes to read that. So now we go to my checklist where it says when you always start a constitutional law analysis, you always start with standing, mootness, and ripeness. You must do that. It must be discussed. And then you'll have in total you'll have seven major components which should take 10 minutes to formulate this outline: the standing, the mootness, the proper plaintiff, proper defendant, the injunction, if you have time, and a conclusion. Okay, so again, from the common law checklist on my website, just justiciable standing. This should be memorized because it's on every constitutional law. A controversy that touches upon legal interests can be resolved by judicial action. Clearly state the injury, right? And the injury was they can't put their flyer up because it's not in Spanish. Is organizational plaintiff. Injury, so this is an organization, it's not an individual, it's an organization. So injury in fact to its members, injury to the group, related to organization's purpose, is participation by the individual members required. It should not be required in order to proceed forward. And was this caused by the government? It's a city, it's a local government. And it's a bus station. So remember that this bus station is there to earn money. So they are a participant in the market, in the commerce stream. So can the injury be redressed? Start to introduce that remedy right away. If it can be redressed, it's an injunction. And you introduce that right here. Mootness. There must be a dispute which continues to present upon which a court ruling may have real consequences. Again, you have to memorize this word for word so it just comes out regurgitated. Ripeness. Is the dispute too hypothetical or ill-defined, which would infer the court providing advice? Court does not provide advice. So since mootness and standing must always first be discussed, you must have this memorized word for word. This part of the outline should take you 2 minutes right here. All right. Okay. Plaintiff as a private organization. So you should have 15 to 20 minutes to write this substantially, the rule statement and so forth. 15 to 20 minutes. Remember, your outline takes 10 minutes. 14th Amendment, equal protection. No state shall deprive any person within its jurisdiction the equal protection of the laws. That's a fundamental right. Aliens are recognized as persons guaranteed due process. That was Plyer v. Doe. And then next, you should be looking at the Bill of Rights. In this case, the First Amendment extends to states through the 14th Amendment due process clause substantive. In the First Amendment, Congress shall make no law abridging the freedom of speech. And it was abridging the freedom of speech and freedom of religion. In this case, this freedom of speech. Regulating the public forum, government acting as proprietor. They're a bus station, they're earning money, not subject to heightened review. City's population is 50-50 English Spanish speaking. Regardless of immigration status, the Spanish necessary to communicate written ideas. Defendant has cited no local, state, or federal ordinances to refuse AAO to use the bulletin board. This seems arbitrary and capricious, and you might want to look at the Dormant Commerce Clause. That's inapposite, but the Commerce Clause may work. It might. Prior restraint. So they're they're prohibiting this speech before it can even make it to the bulletin board. We're not going to let you. So before it's disseminated, and then the remedy would be injunction. So you're looking at the plaintiff side. Now it's time to look at the defendant side. Proper defendant as a local government. The 10th Amendment powers not delegated to the United States by the Constitution nor prohibited by the states are reserved to the states respectively. Again, this is a snip right from my checklist. Police and rule statements too. Police power. States and political subdivisions possess general police power, which permits them to act for the benefit of their residents. 50% of the residents speak Spanish, so they can act this way. First Amendment, time, manner, and place, narrowly tailored and content neutral, intermediate form of balancing analysis. The nature, the pattern of normal activities, overriding principles. It's a bus station, coming and going, so that's a public place for a forum. Discriminating action must further a compelling local state interest. The Dormant Commerce Clause, Article 1, Section 8, the central bus station may have residents from out of state that to pass through must show that prohibition. And there's a pike balancing, even handedly effectuate a legitimate local public interest. Okay, so now you're on to the remedy. If you've got well, how long did that take for the defendant? 15 minutes for the defendant. Okay. 5 minutes if you have it for the remedy. In your if your conclusion is for plaintiff, then take 5 minutes to talk about an injunction. The requirements of an injunction, temporary injunctive relief and permanent injunction relief. That's what you should hit upon. The requirements you're going to rehash standing, ripeness, and mootness very quickly. Rehash it. Temporary injunction is a temporary restraining order for emergency situations. In this case, it would be because they're losing revenue because they can get $10 per person who signs up for their organization. Preliminary injunction is the likelihood of succeeding on the merits and an adequate remedy at law and suffer irreparable harm. Lost income from new members. The permanent injunction, the requirements are a valid claim, imminent and irreparable harm, hardship to the defendant disproportionate to benefit to the plaintiff, must be in the public's best interest, and the duration is determined by the court. Permanent is also specific and definite, and modifications change in circumstances, hardship, or unforeseeable. It can be modified in the future. So your conclusion should take 3 minutes. Do not be conclusory. Summarize major points and make an on-balance conclusion. You're gonna say the plaintiff, say the defendant, and most likely the decision will be right or wrong. Make your conclusion. Okay, this is what the outline should look like. You can press pause for this and read this. AALV City, justiciable standing, mootness, ripeness, proper plaintiff, right? Here's proper plaintiff. Okay. And then we continue on with proper defendant. It's a local government. And then if you have time, the remedy. If you don't have time, then skip the remedy. And then your conclusion is on balance, rehashing. Again, hit pause so you can take a look at this, write it down if you need to. But it's pretty much all in my checklist and my rule statements. Again, this is Stephen Richardson, lawschool-essentials.com. This question was constitutional law. Question number 2 from the February 2012 Cal Bar exam. If you liked what you saw, subscribe. I'm going to be putting many more. I went back to 2012 and I'll work up. There's many questions to talk about torts and con law and criminal law. And so we'll be talking about those. Thanks and have a great day.